start. The sovereign nation of Israel is not and cannot be made amenable to the jurisdiction of this court. Stop. Hence, for this court to consider the grant of the reliefs as such, it would inevitably become necessary to enter a finding in regard to the allegations which have been levelled by the petitioners against the state of Israel. Stop. Absent jurisdiction over a sovereign state, it would be impermissible for this court to entertain the grant of reliefs of this nature. Stop. The second aspect of the matter which requires to be noticed is that the petition seeks a cancellation of the existing licenses and prohibition on the issuance of new licenses for the export of arms and military equipments by Indian companies. Stop. Some of these licenses may be governed by contracts with international entities, including within the state of Israel. Stop. The grant of injunctive relief by this court would necessarily implicate a judicial direction for breach of international contracts and agreements. Stop. The fallout of such breaches cannot be appropriately assessed by this court and would lay open Indian companies which have firm commitments to proceedings for damages which may affect their own financial viability. Stop. Third, the statutory provisions of our law confer sufficient power on the union government if it decides to act in such cases. Stop. For instance, prohibitions can be imposed by the Union of India under the Foreign Trade Regulation and Development Act as well as under the provisions of the Customs Act, 1962 para. Whether in a given case, any such action is warranted is a matter which has to be decided by the union government bearing in mind economic, geopolitical and other interests of the nation in the conduct of international relations. Stop. In taking an appropriate decision, the government bears into account all relevant considerations, including the commitments of the nation at the international level. Stop para. The danger in the court taking over this function is precisely that it would be led into issuing injunctive reliefs without a full and comprehensive analysis or backdrop of the likely consequences of any such action. Stop. The self-imposed restraint on courts entering into areas of foreign policy is, thus, grounded in sound rationale which has been applied across time. Stop para. We clarify that the observations which have been made in the earlier part of this judgment are not intended to reflect any opinion by this court either in the conduct of foreign policy by the government of India. Stop.